Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Today, we are going to discuss the famous legal concept to decide a case of tort. It is Injuria Sine Damnum. Injuria Sine Damnum. Normally, it will be pronounced as Injuria Sine Damnum. You might have noted when the assembly is adjourned without any further date. So it is adjourned sine die. Sine means without. Here injury is there without any damage. Please remember, injury means legal injury. There is legal injury but no damage occurred. Even without damage also, if legal injury is caused, definitely it amounts to tort. So tort is a civil wrong, but not a breach of contract or breach of trust. And when the legal injury is caused, it is remedied by way of compensation by unliquidated damages. So this is the definition. Now we'll see the concept. Injuria sine damno. That means legal injury without any damage. Yes, still it is a tort. So there are two famous case laws. I will tell you three, another also. The first case law, Ashby versus White, 1703. So the subheading is rejection of voters' right to use. Yeah, the plaintiff, that is Mr. Ashby, was a qualified voter. He wanted to actually cast his vote in favor of somebody. He went to the polling booth, but the returning officer rejected his vote, or he prevented him from casting his vote. By some reason, he may not have proper identification like that. Anyway, his vote was rejected. So he was wrongfully restrained. That means he was not allowed to come inside, and his vote was not taken. This is a story in 1703, not now. Now he can go for challenge vote or other things. So ultimately what happened is, the plaintiff, that is Ashby, brought a suit against the defendant Mr. White. So, but here the point is, the person in whose favor our plaintiff Mr. Ashby wanted to vote, yes, he has come out successfully. The defense plea by Mr. White is that already, even though he casted his vote, no purpose would have been served, so no damage has occurred. His friend from whom he wanted to vote, he has come out successful, so no case. But still, the court stated, House of Lords, they stated that even though the plaintiff did not suffer any actual loss, as the candidate whom he wanted to propose has won, but still his right to vote as a qualified voter was infringed, was violated. Therefore, legal injury was done to him. Therefore, the the defendant was liable to pay compensation. It is a tort. Now the second case, Bhim Singh versus State of Jammu and Kashmir, 1986. So in this case, you all know that Bhim Singh was a member of Legislative Assembly of Jammu and Kashmir. So while he was going to attend the state assembly, then the police detained him unlawfully and deliberately prevented him from attending the sessions of the assembly on 11/9/1985. Actually, at that time he was coming on a bicycle. Nowadays, MLAs, they come on only BMW or Mercedes-Benz cars. At that time, they used to come only on cycles. So he was prevented. Now the defense put up by the police department of J&K is that already he was suspended from attending the assembly. So there is no purpose of his attending the assembly. But court held that no, not only the MLA's performance during the assembly sessions is not only to attend. He has went out the grievance of about 1 lakh people to the assembly secretary, to the party members, or to the party. So many people will be there in the assembly. So definitely you were preventing him to go to the assembly is nothing but injuring or infringing his legal right of attending the assembly. As per the constitution also, please remember, the person should not be, MLA should not be arrested during the assembly sessions without permission of the speaker. The Supreme Court held that detention of the plaintiff was against the fundamental right to personal liberty, under Article 20 of the Constitution. they have held like this. And Supreme Court ordered release of the plaintiff and awarded an exemplary damage worth rupees 50,000. You see, now it may come to 50 lakhs. Now, third case, Municipal Board of Agra versus Ashafi Lal. It is 1921. Actually, Ashafi Lal, he wanted to contest as a member of the municipal board. So, he has put in his application, but the municipality, actually, he has put an application to the municipality to correct his father's name, because actually his father's name was not as per the records. Right? So as per the record, his father's name, his name is Ashraf Lal. Father's name may be Sundar Lal, SAN, like that it was in the municipal records. So he wanted for the correction of this name. But the municipality, as usual, the red tapes, they did not do it in the proper time, as a result of which he could not contest for the board elections. Ultimately, he brought a suit against the Municipal Board of Agra. Right? So here, the municipal board stated that he was not elected as a member. It was not, already somebody has been appointed. So there is no point he is contesting. So his legal right is not infringed. That is the defense put up by the Municipal Board of Agra. But so court did not ask, did not admit the same. It is your duty to correct the father's name and give it in proper time. Since you, due to your delay, his right to contest in the elections of the municipal board it has been infringed. Therefore, you are liable to pay compensation. Legal injury was done to him. The court asked the secretary of the board to correct the name of the defendant's father and prepare a fresh voters list and also pay compensation to the defendant. So please remember, these are the good cases relating to Injuria, Sine, Damnum. That means there is a legal injury. Of course, damage was not there. Just like our Gloucester Grammar School, damage was not there. Even then, when your legal right is infringed, when your legal right is violated, when somebody hurts your legal injury, definitely you are liable to get compensation. So therefore, please remember the basic concept. Ubi just ibi remedium. Where there is a right, there is a way. So where there is a wrong done, definitely you will get compensation. With this, I want to thank you very much. So this is regarding Injuria, Sine, Damnum, and in the other video, I will tell you the other concept, that is Damnum, Sine, Injuria, or Damnum, Sine, Injuria. Thank you very much.